A very warm regards to everyone. Today, I'm Darshi Sharma, Assistant Professor, Faculty of Law, Kalinga University, will discuss about national human rights laws. What are these human rights? It's those set of rights which are given to every individual by the virtue of their birth. In India, the makers of Indian Constitution were aware that it is not only easy to wipe out all forms of discrimination, so they developed a constitution which would allow laws to emerge to meet varying needs of all forms of society. The constitution goes into society that is based on certain principles and listed in a very important form of Indian constitution. Any law which is violating the Indian constitutional provisions or a preamble of it will be struck down. Democratic systems strive to perceive equal grounds for all. They allow people to express their opinions and make choices, including the choice of being represented by the people they believe in. This choice is known as vote. Democracies all over the place and all over the people, whether majority or in minority of the same plane, have these set of rights. The Indian Constitution ensures that each person's right, irrespective of their caste, race, gender, religion, creed, are indeed protected. However, these rights are not always without any restrictions. They are fundamental of the personhood and they are guaranteed under Indian Constitution. These are known as fundamental rights. Fundamental rights finds its place in Part 3 of the Constitution. These rights give people a protection from oppressive government, place a duty on government to uphold them. These set of rights are enforceable against the state which is given under Article 12 of Indian Constitution. They are so important that if they are violated by the government, any person has a right to approach the High Court under Article 226 and the Supreme Court under Article 32 directly without going to any other lower court for relief. On January 24, 1947, Constituent Assembly voted to establish an advisory committee on fundamental rights. This committee was chaired by Sardar Patel, Dr. B.R. Ambedkar, Dr. B.N. Rao, K.T. Shah, Harman Singh and K.M. Munshi, along with other Congress experts of the group who drafted the list of rights. Although few revisions were suggested, the essential to no dispute on the included concepts were mentioned under Part 3 of Indian Constitution. The rights enriched under UDHR principles, which is Universal Declaration of Human Rights, were nearly entirely incorporated into the aspects of Indian Constitution. This incorporation was done in two forms. First, under fundamental rights, and second, under DPSPs, that is Part 4 of Indian Constitution, known as Directive Principles of State Policy. The Motilal Nehru Committee report, which came into being in 1928, comprised 19 essential rights, 11 of which are listed under Part 3 and 3 as Part 4A. In Menka Gandhi versus Union of India in 1978, the Supreme Court gave a landmark judgment and held that UDHR, which was adopted in 1948, discussed a very important premise on the Constitutional Framing Committee. And it was assumed that the framers were indeed influenced by this landmark international convention while framing Part 3 of Indian Constitution. Now, where you will find these fundamental human rights under Indian Constitution? The human rights which are classified under Indian Constitution are as follows. The first is right to equality and freedom from discrimination. This particular right is given in the very first article of UDHR and finds its place under Article 14 of Indian Constitution. The right to life, liberty and personal security is a very intrinsic part of UDHR which is mentioned under Article 21. It is the most comprehensive right amongst all the fundamental constitutional rights which is given under Indian Constitution. Freedom from torture and degrading treatment under Article 21, which is also a very important part of UDHR. And UDHR, along with many other covenants, also discusses about torture and degrading treatment, like UNCAT, United Nations Convention Against Torture, which India signed in that particular year but hasn't ratified yet. The right to equality before law, which is mentioned under Article 14 to 16 of Indian Constitution, is also a very intrinsic part of UDHR. Right to free trial, right to privacy, right to health, right to education, and right to social health also mentions a very important aspect of Article 21, which is laid down under UDHR principles. The number of rights that were available in the Covenant were not only available as fundamental rights at the time of enactment of Indian Constitution. For example, ICCPR, that is International Covenant on Civil and Political Rights, grace its importance and can be very much traced in the Part 3 of Indian Constitution. Whether, on the other hand, International Covenant on Economic, Social and Cultural Rights can be traced from Part 4 of Indian Constitution. The judicial interpretation have widened the scope of fundamental rights available in Indian Constitution. In court of ADM Jabalpur versus Shivkant Shukla, the apex court has observed that the law of the land does not recognize any natural or common rights other than specifically mentioned and provided under Indian Constitution. But later, in the case of Maneka Gandhi versus Union of India, Justice Bhagwati observed and commented that the expression personal liberty in Article 21 is one of the widest amplitude, and it covers a variety of rights which go to constitute personal liberty of man, and some of them have been raised to the status of distinct fundamental rights and given additional protection under Article 19. This particular case gave us the example of Golden Triangle, which mentions under Article 14, 19 and 21. Therefore, no person can be deprived of their life and liberty unless there is a law by the state prescribing the procedure to do the same, and the deprivation is effected strictly in accordance to that procedure. In India, we have Protection of Human Rights Act of 1993. This act for the first time defines what human rights are. This says human rights are those rights which are related to life, liberty, equality and dignity of individuals guaranteed by Indian Constitution. The Protection of Human Rights Act of 1993 was enacted to provide a constitution of NHRC, that is National Human Rights Commission, and SHRC, which is State Human Rights Commission, along with human rights courts for the protection of human rights. What is this NHRC but? NHRC is a watchdog of human rights in a country. That is, rights related to these life, liberty, equality and dignity of all the individuals are embodied, which is also under international law as well as under Indian legislations, which were enforced by the courts in India, are protected by NHRC. It was established in conformity with the Paris Principles. It is a multi-member body consisting of a chairman and 4 members. And this chairman will be a Chief Justice of India or any retired judge of Supreme Court. What is the role of NHRC? The role of NHRC is to inquire into violation of human rights or negligence in the prevention of such violation by public servant, either suo motu or on the petition presented to it on an order of court. Suo motu means taking cognizance by itself. To intervene in any proceedings involving any allegation on violation of human rights pending before court. So this intervention can also be done by NHRC. NHRC can also go for visits in jails, detention centers to study the living condition of inmates and make recommendations thereon. To review the constitutional and legal safeguards, NHRC can go for protection of human rights and also recommend measures for their effective implementation. NHRC have also role to review the factors including acts of terrorism that inhibit the enjoyment of human rights and recommend remedial measures. NHRC also studies treaties and other international covenants on human rights and make recommendations for their effective implementation. Human rights and NHRC also undertake and promote research activities under human rights. NHRC can also spread human rights literacy and promote awareness safeguards available for the protection of human rights. NHRC can also encourage the efforts of NGOs, that are non-governmental organizations working in the field of human rights. And lastly, NHRC can undertake any such functions which make the Commission can consider necessary for promotion of human rights. But this role of NHRC is merely a recommendatory in nature, and that is the reason why it is known as a toothless tiger, because NHRC can only give recommendations and cannot dictate the terms. It cannot ensure that the rights and recommendations given by the NHRC is applicable and has to be followed by the people. So NHRC can only give recommendations, suggestions, can prepare reports, can give the guidelines, but NHRC cannot make sure that these recommendations have been fulfilled. So their role is very limited in nature. Yes, the scope is wide, but the application and the implementation is very limited. Thank you.